Tanya, can you hear us now?
I can hear you.
You can hear me. Okay, and you are present, correct?
I am. Yep.
All right, thank you. Ibrahim. Excuse me. Ibrahim absent. Knudsen.
Present.
Knudsen present. Ladd. Ladd absent. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell.
Present.
Schnell present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 9 members present, 2 members absent.
All right, thank you. First item on the agenda is approval of the agenda. I would entertain a motion to approve the agenda.
So moved.
Commissioner Schnell makes that motion. Do we have a second? Second. Commissioner Larkin seconds. Any discussion? Hearing none. If you take the vote, Nate.
To the Schnell motion to approve the agenda, Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim absent. Knudsen?
Yes.
Knudsen, yes. Ladd? Ladd absent. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Present. Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Next item is approval of the draft meeting minutes from October 6, 2022. You should have received, actually, you all received them 2 weeks in advance. So should have been plenty of time to look them over. I would entertain a motion to approve the minutes. Commissioner Middlebrook moves to approve and Commissioner Larkin seconds. Any discussion? Hearing none, if you could take the vote on that, Nate.
To the Middlebrook motion to approve the October minutes, Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim absent. Knudsen?
Yes.
Knudsen, yes. Ladd? Ladd
Sure.
absent. Larkin?
Commissioner Larkin?
I just received a text message from Commissioner Ladd. She says, I'm on the phone, couldn't get logged in. Otherwise, I sent 2 emails to Nate.
Okay, all right.
Sorry,
No,
it just came.
That's good. So let me, let's have the staff work on that. And let's, since we have a quorum, let's finish this vote and then we can take a break if we need to get Commissioner Ladd online for sure.
And my vote is yes.
Can I just ask a question of Commissioner Larkin?
Yeah.
If you could ask her what the first digit of her 7-digit phone number is.
Oh, he might need to elevate her.
Yeah.
I got it.
I got 2 218 numbers,
All right.
and I can only see the first 3.
Ends in a 6. Or you can only see the first
I need the
3.
first digit of her 7-digit phone number.
I'm sorry, 2.
2. All right.
Got it?
Yeah, I got it. Thank you. All right. Commissioner Ladd, can you hear me?
I can hear you. Can you hear me?
Yes. All right, so Commissioner Ladd is present. Commissioner Ladd, we're on a Middlebrook motion to approve the October minutes. Do you have a vote?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay, we now have everybody online that we expected to be here, right? So we have 10 out of 11?
We do, Officer Ibrahim was called to court, so
Okay.
he's unable to attend.
Great. Okay, awesome. Where are we? Oh, we are now at a review of public hearing process. That's you.
Thank you, Madam Chair. So we are at the stage where if the commission wishes to make amendments to the sentencing guidelines, it has to have a public hearing before it does so. Because of the time requirement, and that public hearing requires a 30-day notice period, and that notice has to be published in the state register. So due to all that, in order to get the public hearing in by December 14th, which is our currently scheduled meeting date, any actions that the commission wishes to take with respect to changing the sentencing guidelines in 2023 has to be decided on at this meeting. And then we would have a public hearing if there are any such actions on December 14th. The commission would still have its meeting on December 14th. The meeting would happen immediately after the public hearing is over. And yeah. So that's pretty much how that goes.
Okay, any questions? Okay, so then we'll move on to item 5, which is guidelines modifications resulting from the sex trafficking review. So just to note, we are today only considering changes relating to aggravated sex trafficking and the potential to classify some forms of sex trafficking as severe violent offenses. I have delayed, I've pushed the prostitution considerations to next year. I don't think that most of us were really ready to take a vote on that issue. So my intent would be for us to continue to work on that next year. It also was not one of the things we were required to look into under the statute. So this will allow us to get the aggravated sex trafficking issue addressed and sent to the legislature, put in our report, sent off to the legislature this year. And then if we can continue to work on whether we want to do anything different with those prostitution offenses. So let's start with item A, which is whether to replace the aggravated sex trafficking modifier with severity rankings. How do you want to lead us through this?
Well, we were kind of light on materials. We were kind of heavy on materials last month. So we got all that background material from last month's meeting. If you're interested in it, all we really have this month is the impact, well, the draft language for ranking aggravated sex trafficking, which there are two options there. There's the yellow option, the blue option. Well, I mean, there are three options basically the commission's discussed. One would be status quo, just don't make any changes, just keep it as a modifier. The other two options both involve eliminating a modifier and replacing it with a severity ranking. The option that's what we're calling the staff alternative that's indicated in yellow is the option where first degree aggravated sex trafficking would be ranked at severity level A, and second degree aggravated sex trafficking would be ranked at severity level B. So that would maintain the existing distinction that the commission makes between first and second degree aggravated sex trafficking. The alternative indicated in blue highlighting is the alternative recommended by the Central Minnesota Human Trafficking Task Force, and that would rank all aggravated sex trafficking at severity level A, whether it's first degree involving an adult victim, a child victim, or second degree involving an adult victim, and that would give honor to the legislative decision to put all of those at a statutory maximum that's the same. Now, when I say yellow and blue, most of the changes are identical for both options, so I don't want you to just think that the only thing that's being changed is highlighted. All the changes are indicated by underlines and strikeouts, but where they are different, the yellow option indicates the staff recommendation and the blue option indicates the Central Minnesota Human Trafficking Task Force option. With respect to the impact, really not a significant impact either way. The estimate is that there would only be minimal changes to, well, an increase in capacity needed for, let's see, it would be 5 prison beds. Jill, is that 5 prison beds for either option, either the, oh no, that's option 2. Okay, so I'm sorry. This was done while I was on vacation. I apologize. So it's 5 prison beds for the staff recommendation and 11 prison beds for the Central Minnesota Human Trafficking Task Force recommendation. That would be the impact, and the demographic changes are what would be minimal.
I think you're talking about the impact of identifying offenses as severe violent offenders, right?
No, so I'm looking at 5A2. 5A2 is the impact for ranking them as, and I think I was getting mixed up with that. But there is an impact, there is an estimated impact of 5 beds for ranking, changing this from a modifier to ranking at severity level A and B. And there's an impact of 11 beds of abolishing the modifier and ranking at A only.
Okay, got it. Thank you. All right, yeah, Commissioner Larkin.
I'll start the bidding. I was convinced, and I thank staff for presenting the reports. I support staff's recommendation that we do away with the 48-month enhancement, go with a ranking which is consistent with most everything else in the guidelines, and that we rank first degree at severity level A, second degree at severity level B, to be consistent in terms of how we treat the different ages.
Okay, so we have that motion. Do we have a second?
I'll second that.
Commissioner Knudsen seconds. Any discussion on the motion?
It's just for using that and trying to figure out what the proper guideline sentence is just so much easier if it's embedded in the guidelines and their severity rankings instead of determining some aggravating factors and enhanced factors and how do we determine, who determines. So I think this is a very big change.
Yeah, and I think it makes the ranking more, the range that's applicable to the sentence more clear. No one has to calculate the range. It's just right there on the grid. So there's that too. Other comments or discussion? All right, well, hearing none, let's go ahead and move to a vote.
To the Larkin motion to advance to a public hearing, the staff recommendation to abolish the aggravated sex trafficking modifier, substituting for it a ranking of first degree aggravated sex trafficking at severity level A and second degree aggravated sex trafficking at severity level B. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay, moving on to whether to classify some forms of sex trafficking as severe violent offenses. At the last meeting, you gave us a pretty significant rundown of how we have in the past chosen to add things to the severe violent offender list. You also gave us a multitude of options for what we could potentially add. If we put any of these on the list, which ones we could do. And the one suggestion put forward by a member of the commission was to consider options 2 and 3. So I don't know if you want to quickly explain that and what the impact is. So
5B1 is the same document that we sent you last month. It's basically the entire history of the severe violent offense list as I was able to recreate it together with all these options. But the reason I'm including it again is because it also has the text. So for example, footnote 17 contains the text of option 2, which is pretty simple, basically adding one line to guideline section 8, and then footnote 18 shows the text of option 3, which would be adding 3 lines to guidelines section 8. So that's why I gave you this document again, so you can see that's what you would be voting on if you were voting to adopt either option 2 or 3. And I bring those up because those were the options that were discussed at the last meeting. 5B2 contains the impact, and that's the document that indicates that we're not anticipating, we weren't able to determine that there would be any impact from this necessarily. The number of cases that would be affected, at least within our sample size, was just, we couldn't find a case that this would meet. So we aren't estimating an impact, whether prison bed or demographic.
Madam Chair,
Commissioner Larkin.
can I just clarify when you say option, the 2 options we're referring to, one option is add first degree, the second option is to add second degree? No? Then I need an explanation.
Okay, so option 2 would be to add only to the severe violent offense list those aggravated sex trafficking offenses that actually contain an element of either bodily harm or debt bondage or forced labor or services for more than 180 days. Which is like labor trafficking, which is on the severe violent offense list. So that to me, it seems, I mean, if I can editorialize just for the purpose not of inserting my opinion, but just to clarify what this proposal does, it seems to get at the core of what is on the severe violent offense list. Offenses that are severe, and these are all severe. They all are of a high enough severity level that they meet the severity criteria, which we assumed was a presumptive commit any criminal history. And these are also violent in the sense that bodily harm is required, or the debt bondage or forced labor services. That's option 2. Option 3 adds to that offenses involving children. So it'd be aggravated. So it would be all, let me just find 3 here. So option 3 would include all sex trafficking in the first degree, whether aggravated or not, because all sex trafficking in the first degree involve children. There's now the pattern is not to include age cases, age crim sex cases. So there's a little bit of a disconnect between adding the first degree non-aggravated cases, but this is also a different kind of sex act. This is a commercial sex act. So you're basically putting up a child for a commercial sex act. So if that is considered to be, if you consider that to meet the violence criteria, basically, then you could vote for option 3 as well. And in addition, it includes for adults the aggravated circumstances that we talked about with option 2. And that would be the bodily harm, forced labor or services, or debt bondage. So if those are present with an adult, then that would apply under either option. And option 3 would apply to all children.
Commissioner Larkin.
Is the list in the guidelines or is it statutory?
The severe violent offense list is in the guidelines.
It's in the guidelines.
It's also
He
on our
reproduced it in his handout.
I don't have the handout and I don't have a computer and it's not on the screen.
Got it right here.
But could somebody just tell me where in the guidelines it is?
Section 8,
Section 8.
yes.
I have a book. How's that for old fashioned?
It's almost at the back.
Yeah, all right. Thank you. I just want to look through that real quick.
I almost brought my. So much easier.
Oh, it's a short list. It's not like the statutory list.
No, the commission was very selective in creating the severe violent offense list.
So just to recap, Option 2 is only add those sex trafficking offenses that have an element of bodily harm or a length of service. Or option 3 is add all of first degree because those are children, and then the rest only if they have the bodily harm and, okay.
Yes.
So I guess I would be in favor of option 3.
I would second that.
Commissioner Moran, are you putting it forward as a motion?
I put forward as a motion
Okay.
that the commission adopt option 3.
All right, and then Commissioner Moran is seconding that motion. All right, any discussion on the motion? All right. Hearing none, I think we can move to a vote.
To the Larkin motion to advance to public hearing, the ranking of certain sex trafficking, the adding of certain sex trafficking offenses to the severe violent offense list as described in option 3 of the staff paper. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, it passes unanimously. So just so you all get your reading glasses on, staff is going to have to write up a summary of our review of sex trafficking to include in the final report. So we will be seeing that in the next meetings. I'm not sure. I guess our next one is December. So you'll be seeing that in the December report. So just be ready to review that content because it will also sort of detail the steps we went through to review this, to do the overall review. Just want to give you a heads up that you'll have some reading to do. Okay.
And we're gonna give them a kind of a preview of that. We're gonna look at the
Yes.
other issue as well.
Yes, absolutely. Yep, that will be in there as well. You ready to get your writing pen on?
Yeah. We got a nice break between this meeting and the December meeting, so
You think you have enough time?
should get it done.
All right. Okay. All right, so moving on to item 6 is custody status related guidelines and modifications. I think the new material since last time is the impact of the more recent proposal. I don't know if you want to go through that real quick or if you had anything in mind.
I did, yeah, we do have the impact, and we also have, I did change a little bit on the draft text for eliminating the half custody status point. Some style changes, I think just making it more readable. And then we also have draft language for both the elimination of the custody status point and then Commissioner Larkin's October proposal to, I guess you could say, conditionally eliminate custody status, to eliminate the half custody status point, restore custody status as it was prior to 2019, but then conditionally eliminate custody status for low-level felonies, provided that the custody status was not the result of a mitigated departure from the guidelines, mitigated dispositional departure, I believe. Is that correct? And then nor did the defendant have a criminal history score of 6 or more, not counting the custody status. And then also conditionally eliminate custody status for misdemeanors, gross misdemeanors, and non-traffic DWIs and gross misdemeanor DWIs. Again, on the condition that the defendant has a custody status, a criminal history score of less than 6, not counting the custody status. So essentially, for low-level felonies and misdemeanors, custody status would only count toward the 3-month bump, that additional 3 months that you get if you're off the charts criminal history. Although for low-level felonies, it would also count if the defendant had received a mitigated dispositional departure previously. And we do have the impact estimates of those. We had previously provided an impact estimate of, on the first one, that was revised just a little bit. We're now looking at 11.5, 11.5 prison beds that would no longer be required if the half custody status point were eliminated altogether. And just to be clear, this is not eliminating custody status. This is just eliminating the half custody status point, which is very close to the way the status quo is, because under current Court of Appeals interpretation of the sentencing guidelines and consistent with the Commission's interim guidance in January, the half custody status point is effectively being disregarded for most purposes other than for the 3-month bump right now.
And Madam Chair,
Commissioner Knudsen.
and so that's what's outlined in Exhibit 6A2 to the agenda.
Yeah, 6A1 and 6A2 are related to the proposal, which was, I think, effectively the July Larkin proposal to eliminate the half custody status altogether, essentially to codify the Bogdanovich decision. Although it would go a little bit beyond Bogdanovich because it would also eliminate the 3-month bump. And then 6B1 and 6B2 have to do with the October Larkin proposal to conditionally eliminate custody, well, to restore full custody status point, but conditionally eliminate custody status for low-level offenders with low criminal history, provided that the custody status did not result from a mitigated dispositional departure. And for that, we estimated
Did that
100.
answer your question?
Oh, yeah.
And for that, we estimated 161 prison beds. So there is an impact to that proposal.
For the newer proposal?
For the October Larkin proposal, there's a more significant impact than, well, it actually goes the other way. So it would be an increase in prison beds, whereas the other would be a smaller decrease.
Commissioner Larkin.
Thank you. So with both my proposals, I'd like to speak against my first proposal in favor of my second and move my second proposal forward to the public hearing in December. When I said in July, let's just codify Bogdanovich, as I said in my written materials, it's a place to start. I mean, it's where we are now. It's something to start with. But for several reasons, I don't think that's the direction we should go, mainly because the Court of Appeals is not a policymaking court. It's an error-correcting court. There are several factors, I think, that have come up again and again as we've talked about custody status. You know, we don't want people crossing the line into a presumptive commit for low-level offenses as a result of custody status. We don't want to overpunish low-level offenders by having this custody point. On the other hand, we want to ensure that we have adequate consequences for high-level repeat offenders, violent offenders. So, you know, these are the concepts we talk about in trying to decide as a policymaking group what we should do with custody status. I mean, I wasn't on the panel that decided Bogdanovich. I had nothing to do with it, but I can assure you that they didn't talk about policies when they decided this. They looked at the guidelines and they said, there's nothing in here that says you can round up, therefore you can't round up. That's what we do. We just nuts and bolts, plain language. So I agree with the chair who expressed concern that the appellate court shouldn't be setting sentencing policy, except perhaps the Supreme Court, which is a policy-making court. Certainly our court shouldn't be doing it. So I think we do a disservice to simply say, well, let's just adopt Bogdanovic. I threw it out there as a starting point, expressed reservation about taking targeted misdemeanors out of the custody discussion. So I speak against it today. I also speak against, the notion that even if the majority were going to go with the Bogdanovic approach, that we would eliminate the 3-month add-on, because Bogdanovic doesn't address that. And the plain language of the guideline says if you're 6 or more. So if you're 6.5, that's 6 or more, and you should have your extra 3 months. So I'm opposed to that idea. I think any resolution we propose should be based on sound policy. And when I came up with the second proposal, my thinking was this. Okay, it used to be all these folks got 1 point. Then we went down to a half point. Why did we go down to a half point? Who do we want to continue to benefit in terms of low-level offenders? Who do we want to not avoid the impact of a custody point? And that was one of the concerns expressed about Bogdanovic at a meeting, that the commission intended the half point to have some effect. And under the Court of Appeals decision, it has no effect for everybody, whether you have a criminal history score of 2 or a criminal history score of 8, and that doesn't seem appropriate. So what I simply tried to do was come up with a proposal that would, I hope, focus on the serious repeat offenders, and not over consequence the low-level drug offenders, and not put somebody in prison based on a custody half point. So my thinking was, all right, let's just go back to 1 point for everybody and get rid of half point altogether, but let's carve out those circumstances where you get no points, and those would be the D1, D2, the lower 2 on the regular grid, unless the offender is already maxed out on criminal history points, because that person on the grid is already going to prison. They've already crossed the line by the fact that they have 6 prior felony conviction points. And the other idea was, let's accept out people who are on custody status as a result of a downward dispositional departure. My thinking being, that person was supposed to have gone to prison. The person got a downward departure, was put on probation. So it's not just a matter of, well, somebody was on custody status and picked up a new felony or a targeted misdemeanor or whatever, because it would be a new felony. It's a matter of that person was supposed to be in prison, was put on probation, and still reoffended. And I would assume anybody who gets a downward dispositional departure from a presumptive commitment offense would be on some form of supervised probation, so we wouldn't have the concern that, well, this person didn't have the services he or she needed or the level of supervision. And it seems to me that that person is the person who's entitled to a custody consequence, even if it is a new lower level offense. So I was really trying to incorporate the concerns that I heard, and I think this proposal does it. I don't know that it's the best proposal, but after 2 years on this, I think it's the closest we've come to some sort of compromise that keeps the points for some people, gets rid of the points for other people in a way that's consistent with the discussions we've had. So I would move to adopt and go to a public hearing with my second proposal. That said, there is one substantive issue that I'd want to address if there's support for going forward with the proposal in the first place, but I'll leave that unless you want to preview. Preview? And I had talked with
Yeah. Oh, I know. I have to ask for a second first. Is there a second to this motion?
I'll second I think it's the September proposal of Judge Larkin, our commissioner.
Okay, so we have a motion and a second. What was your preview?
The second issue is this, and I saw this when I was going through the draft language. The guidelines seem to be inconsistent in terms of whether you need to have a conviction for your custody offense to get the custody point. The way the rule is written or proposed, which is consistent with the current language, it references, you need to have a guilty plea, a guilty verdict, or a conviction, suggesting that a conviction is an alternative, but not a necessity. And indeed, a guilty plea or a guilty verdict does not result in a conviction. It's the court's acceptance and recording of the guilty plea or the guilty verdict. But later in the guidelines, there's a proposal to say, well, a stay of adjudication shouldn't get, if you're on a stay of adjudication under probation supervision, that doesn't count as custody status because it's not a conviction. And then there's a comment that says the custody status is covered by this policy are those occurring after conviction. So I think the guidelines are a little bit inconsistent as to whether or not you need a conviction to get a custody status. I don't think we should require a conviction to get the custody point so long as you've pleaded guilty or there's been a finding of guilt. And here's why. An example, you could have two people, same crime, same criminal history, same plea deal. They go before the district court. One judge hears the plea deal and says, yep, I'm fine with that deal. I accept your plea. I adjudicate you guilty. That person's convicted. If that person picks up a new offense before sentencing, that person will get a custody point. The person in the other courtroom, the judge says, this might be too good of a deal. I'm not sure I'm going to sign off on this without a pre-plea investigation and a criminal history worksheet. So yes, you've tendered your plea. I'm not going to accept it until we come back for sentencing and I have those documents. Well, technically that person doesn't have a conviction, but if that person then goes out and commits an offense that would result in a custody point, a person's not going to get the custody status point. I don't see why we would treat those two people differently. And on a stay of adjudication, not always, but most times, well, first of all, stays of adjudication are pretty rare in adult court. And if there is a stay of adjudication, there usually is probation. So I don't understand why we're tying the custody status point to a conviction. If that is in fact what we're doing, it's not clear to me that we're doing that. And I'm aware that there was this reference to stays of adjudication under 152.18 and we took that out, but I don't know, to me, I think we should clarify whether the assignment of a custody status point requires a conviction for the custody offense, because I think the guidelines aren't clear and we have an obligation to make them clear.
Okay, spinning my brain inside out with that particular
Sorry.
issue. I did a whole master's thesis on that topic, but Catherine, Commissioner Middlebrook.
Thank you, Madam Chair. Just to your last point, Judge Larkin, I thought that I was looking at the language of the guidelines. It does say after entry of a guilty plea, guilty verdict, or conviction. So it would cover both scenarios with your example of someone who's basically adjudicated after they plead, or if it's held over till they get to sentencing. It would cover both of those situations. And believe me, we've seen these come through like that in my office. But and we particularly took the stays of adjudication out as part of that package back in 2019, because I think that the 152.18s were already not being included. I mean, that was part of that, and that's why there's that difference. But I do think that the current language in the guidelines covers both of those.
Then can we lose the comment that says you need to have a conviction? Because that's what the comment says. And I know you can say, well, the comments aren't law, but why have a comment that is inconsistent with what we believe the rules mean? The custodial statuses covered by this policy are those occurring after conviction. Doesn't that
I think
suggest you need to have a conviction? And that's 2B205.
okay, so I think that's something we can definitely look into. Commissioner Moore.
I agree with Commissioner Larkin's point here. My practice in district court was to rarely accept a guilty plea until I'd seen a sentencing guidelines worksheet, just because of, assumptions being made on criminal history that didn't end up manifesting themselves on the actual worksheet that we got. And, I didn't want to have myself trapped into a corner after having accepted a guilty plea and adjudicated someone guilty and then finding out that what everybody thought was a, presumptive stay became a presumptive commit. And I basically was departing without agreeing to it. And so I think this is a valid concern. And the comment does say conviction, after conviction of a felony. And I think that does need to be addressed. I agree with Commissioner Middleburg's comments that the actual guidelines language does say guilty plea, guilty verdict, or conviction. I think it should be consistent.
All right. I'd like to comment regarding the motion. I have concerns with that approach. My first concern is I think it's too complex. I couldn't even understand it when Nate was trying to describe it today. And I think at the end of the day, it becomes very complex. It seems like there's a lot of hoops to jump through to try to figure out if custody status applies or doesn't apply in the particular case. So, I want our goal to be simplicity, and I don't think it accomplishes that. My second concern is when the commission created the half point, it was in recognition of the fact that in some instances, the custody status value that was being added to criminal history outweighed the value of the points being given for the offense itself. And so if we increase custody status back up to 1, then we are still, we're back to the situation where we have custody status outweighing the value of the prior offense. And I just don't think that should ever be the case. I don't think we should be creating a policy that makes a person's status more important than the fact that they committed that offense in the past in the first place. So I don't support it. My preference would be for us to codify Bogdanovich. That'd be my preference. But I also hear you when you are talking about the folks who have a criminal history score of 6 or more. And so, if your thing didn't pass, or if your proposal didn't pass, then I think I'd be more open to going to Bogdanovich, and I would hope that if maybe we could consider putting those people who have 6 or more points, maybe it still does apply to those cases. Maybe we slightly modify the way that the Bogdanovich proposal is in front of us. And maybe that would be a compromise between sort of where you're going with it and where the original proposal was. I think that might be sort of a better overall resolution at this stage. We did just agree to, let me go back. There's a third reason that I'm concerned about your proposal and why I prefer the other one. And that is, as we have listened to the public on this issue over the past several months, the issue that has come through very loud and clear is that the public is concerned about repeat violent offending. And the folks who have this half point are not necessarily repeat violent offenders. They are people who have had a low-level drug or property crime in their past. And so even if they committed a new crime today, they did not necessarily commit a violent crime in their past. So they're not the target that the public is concerned about. Now, I do think it is a valid question for us to be looking at. How do we handle repeat violent offenses? I would hope that we would begin to take that up in the new year and take a very holistic review and look at what the guidelines do and how they function and what that does for sentencing. And are there places where we should be changing our policies? But I don't think that this change today addresses the public concern. So, and in fact, this whole issue is not related to the public's concern about repeat violent offending. So to me, the more balanced approach would be to codify Bogdanovich. If a compromise is needed, I'd be willing to say, okay, if you have a criminal history score of 6 or more, we're still going to apply that custody status even if your prior was a low-level offense. Or we're still going to add those extra 3 months. That's what I'm trying to say, the extra 3-month provision, we could keep that in. But that's my sort of overall take on the issue. Commissioner Estrada?
I would just say I share those same concerns that you listed and would add a couple of other concerns. We can't lose sight of the fact that this proposal increases prison beds by 168. We have to look at the breakdown of that as well. This commission made a commitment to, look at racial disparities in all of our policy making. And I can't help but notice that, this proposal would increase specifically the American Indian population by 2.9%. Our Native American indigenous populations are already overrepresented in our prison system. And once again, this would be a policy that significantly impacts them. I also want to just kind of point out a little bit, and we've talked about this before, but the assumption that a downward dispositional departure automatically would mean that you have supervision that would be one-on-one where you get the resources is not accurate. We use evidence-based practices, we use tools. It's not uncommon that we may have a first-degree aggravated, assault or a higher level offense that is a presumptive that may score low risk and doesn't have that, one-on-one supervision. And yet this proposal would give them a custody point, even though they don't have kind of that counter argument. So I just want to point a little bit about that. That is what gives me pause in some of this proposal is those dispositional departures, along with what the chair already mentioned. I too would be in favor of codifying Bogdanovich. I do have concerns similar. I don't know what those offenses and what the population looks like for people who have 6+ criminal history points. So I would ask that if we do end up going that well, if that's a possibility, that staff come back with those statistics of who is it that has the 6+ points and what kind of offenses are those. But I cannot support the proposal that is on the table right now.
Commissioner Larkin?
I just, I think I have a hard time seeing how we say to the public, it serves public safety to, these folks currently get a half custody point. That half custody point is supposed to have some impact on their sentence. If you go with Bogdanovich, you're saying it has no impact on their sentence. So you've essentially reduced their sentence because they're not getting, some impact, which was intended by the commission. And you're talking about doing that for everyone. So, let's say you've got aggravated robbery, first degree with a gun. That's 48-month commit. Those offenses often get a dispositional departure. How do we say to the public that somebody who committed an aggravated robbery, who was supposed to go to prison, who was given the opportunity to avoid prison, who committed a new offense while on probation, shouldn't have some additional consequence? Or how do you say to the public, somebody that has, 4, 5, 6 prior points as a result of convictions, and who then picks up another offense and is convicted while on probation or some other form of custody status, shouldn't get the extra consequence that is supposed to be coming from their custody status under the current rules. So, Bogdanovich eliminating the half point is not consistent with what the commission did when it adopted the half point. The half point was still supposed to have some consequence. One of the other proposals I made was for a half point grid, which would be the one sort of consistent across the board, treats everybody the same. So that option's out there as well. I just don't see how it serves public safety to say that we're going to adopt a Supreme or a Court of Appeals decision as our policy, even though that decision isn't based on any policy, and even though the result is inconsistent with what the commission intended when they merely reduced the impact of a custody status instead of eliminating the custody status. And those are just my views.
Just to clarify, I'm sorry, this
Commissioner
was
Estrada?
a bad example that I used on the downward dispositional departure, but the example of a first degree ag robbery wouldn't qualify for a half a point to begin with. They would still get the full point.
Why would they get the, if.
Because with Bogdanovich, it's only eliminating half a point.
Right, but if somebody is on probation for egg robbery and they commit a fifth degree drug offense, it's a half point, right? Because isn't the custody
It's a
point?
full point.
Why
On
is it a
the
full point?
prior.
It's the prior
It's the
offense.
prior that gives cause the custody point.
I thought it was the new offense. No, so it's the prior.
Custody.
Prior. So they might be on custody status for a prior fifth degree drug possession. They might commit the crime that you're
Reverse
saying,
it. Okay.
right? But then we would have, they'd be at higher severity level. They would get criminal history. If it's a gun involved, there's a mandatory minimum. There are things that increase the penalty for that new crime. And custody status isn't the only option out there for that. Commissioner Knudsen?
Point of clarification on the estimate of the prison beds. Nate, what is the base comparison being made against, is it Bogdanovich or is it?
Yeah, so the literal status quo is, it's complicated. So what we're assuming is, so there's a reading of Bogdanovich where it just says that you're supposed to disregard the half point in calculating the criminal history score. If that were true, then basically the first proposal would be literally codifying Bogdanovich. But we're not assuming that that's the status quo because we're assuming that the 3-month bump still applies. There's nothing about the rounding error, which is the precipitating event for all of this. And there's nothing about the rounding error that applies to the 3-month bump. So what we're assuming for the status quo is that the half custody status point will not move you across the grid. It will not alter your criminal history score in terms of getting you across the grid at all right now under the status quo. But under Bogdanovich, under the status quo. So under the zero impact, like what is the starting point? So what we had to do is take all the data and convert it into the post Bogdanovich status quo, is what I called it when I was driving my research team mad, trying to come up with how we're going to analyze this. So the post Bogdanovich status quo is disregard half points for purposes of getting you across the grid, but consider half points if the criminal history score is 7 or more. And just a bit of a correction on what, or maybe clarification on a point Judge Larkin made earlier. It's not 6.5 or more, it's 7 or more. So that's one reason why there's impact in Judge Larkin's proposal is, so because the guidelines say 7 or more, if I have a criminal history score of 6 without my half custody status point, and I have a half custody status point, my total criminal history score is 6.5. So I do not have a criminal history score of 7 or more. And in fact, I think even rounding down, if I have a criminal history score of 6.5 plus a half, because of Bogdanovich, you round down to 6.5, add the half, you still don't get to 7. So I have to have a criminal history score of 7 without the custody status point. Plus I have to have a half custody status point. And then, and only then, under the status quo as we're assuming it, do I get the 3-month bump. So one of the reasons why the more recent Larkin proposal has some impact is because because it gives a full custody status point to those low-level offenders. If I have a criminal history score of 6 plus a custody status point for, say, a targeted misdemeanor, then I get the 3-month bump. Whereas that's not true under the status quo. That confused me as I said it, Judge, so I apologize, but.
So it seems to me, we're trying to fix a problem that we created, we had, pre-Bogdanovich.
Yeah.
And so we didn't make the Bogdanovich decision. We didn't estimate bed impact. We don't, so if we ignore Bogdanovich and say, well, this is what we created, this is what we had in sentencing, in the sentencing guideline practice of a half point. That was the policy that was adopted by the Guidelines Commission. And now we're going to fix that, and we're going to adopt one of these options. Do we have bed impact where the base comparison is pre-Bogdanovich? And the assignment of half points.
Yeah, well.
And then comparing these proposals.
So everything that's on the table would have a bed reduction compared to the status quo ante as it existed in 2018.
Well, that's what I want.
If that's your baseline, then yes, all these have a bed reduction. But what we operate on, we're doing this just like we do a fiscal note. We look at what is, the first question we've got to decide is what is the status quo? And what we are assuming is the status quo is the world in which we find ourselves post-Bogdanovich, which is that a half custody status point will not move you across the grid, but it will give you a 3-month bump if your criminal history score is already 7 or more.
No,
Commissioner.
I understand that, but going back, it's, in my mind, it's misleading to have this estimate change in prison beds when the commission adopted a policy and now we want to modify that policy. So what was the bed impact prior to the adoption of the half point? And then what's the bed impact at the half point? And what's the bed impact on the proposals that we've got? And I think you mentioned it, it's a reduction in beds.
The unfortunate thing, Madam Chair and Commissioner Knudsen, is what the commission intended to do in 2019 and what it did in 2019 were two different things because of my drafting error. So it's not a simple task to figure out what the status quo is. The status quo is not what the commission intended to do because it didn't adopt what it intended to adopt because of the drafting error. So,
well, I would agree with you. What the status quo is with Bogdanovich is not what the commission intended to adopt.
I think what Nate is trying to say is the reality is that we did not incur beds over the past 2 years because of the half custody status point, because it wasn't being applied due to the Court of Appeals case. So so those are real beds that are not filled in prison, and changing the policy today will fill them in a way that they're not filled today. So I think that's really all he's trying to say. Commissioner Middlebrook and then Larkin.
Thank you, Madam Chair. Just maybe to try to clarify, because I was on the commission, as was Commissioner Estrada at the time that the half point was adopted. And I believe we had a bed impact for each of those changes back then. I'm pretty sure we did, and that the half point at that point did reduce, but on the other hand, we also did the whole severe violent offender modifier to increase sentences. So we were looking at, a balance on all those different provisions that were in that, that combined that combined policies. So that's been basically the status quo. I think when Bogdanovic came down, the Court of Appeals, and I agree they're not a policymaking court, but they did use our interim guidance policy and followed that. So that was our policy that we did in the interim while we were giving guidance to the practitioners. It seems that following, basically codifying our interim guidance gets us where basically the status quo. So I don't know if that answers the question a little bit, but I think the reason that it's hard to give you a total baseline is because of these various changes that happened, and then how we're looking at the data from 2021, which is what these proposed, the impact, the two reports are based on that, the data from 2021. So, can I also comment on?
Sure.
So I just wanted to also add, I do have concerns with the second proposal that Commissioner Larkin has put forth. I'm not going to echo what the chair and Commissioner Estrada have already commented on, but I do think it's really significant when we're looking at the increase in the beds at 168. That's pretty significant. I'm really concerned about the increase in the racial disparity, both for the Black population and the American Indian population. The other thing is that it's pretty complex, and I guess looking at it from a practitioner's standpoint, and I would think that probation is going to have the same issue, is just trying to go through all these steps to figure out what's going on in order to see whether or not these low-level property and drug offenses were in a custody status, if they had a dispositional departure. There's a whole lot of factors going on that seems like it's going to make it a lot more difficult to follow that and to get a worksheet for the court to be able to determine all those different things. Again, there's a lot of overlap between the two proposals. And I guess I still think that the other proposal to codify Bogdanovic or our interim policy is the better one to satisfy right now. I also think that this is definitely an area where we can look at on the comprehensive review, where we can really take a hard look at on repeat violent offenders. Do we want to give them, do we want to weigh that heavier? Do we want to take other factors into consideration? But I mean, for the time being, we do need to decide this issue for everybody right now. So,
Mr. Larkin.
Just to respond to all. First, on the comprehensive review, it's my understanding we're not doing a comprehensive review unless the legislature gives us $500,000. So that may or may not come to be depending on the legislature's deal next year. My recollection, and I could be wrong, is that our interim guidance was based on an unpublished Court of Appeals case. I don't recall, but I don't think we came up with our interim guidance on our own. I think we said, well, here's an unpublished Court of Appeals case, here's what they're saying, and we incorporated that into our interim guidance. So I don't think it's fair to say, well, all we're doing is writing our interim guidance into the guidelines if the interim guidance is also based on an unpublished Court of Appeals opinion, which has even less value in terms of decision-making and precedential impact. Prison bed increase, I don't know. I guess I feel like in this commission, if anything's going to increase a prison bed, we're not allowed to do it. I don't know if that's the unspoken rule, and maybe, I don't know how 168 compares to anything else. I'm pretty new still to the commission, but I'm not going to vote against something simply because it will increase a prison bed. I don't think that is consistent with public safety. I think there is a need and a use for prison beds, and we can't ignore that. And I apologize for misspeaking regarding what governs the weight assigned to the custody status. And now that I've been corrected on that, I still have a public safety concern, because even the way it is now, if a person is on probation for fifth-degree possession, so low-level offense, and then goes out and commits an ag robbery, well, isn't that person a repeat violent offender? And why isn't that person getting the custody consequence? So, I mean, maybe we should be looking at, maybe the new offense should govern whether or not you get the custody consequence as opposed to the underlying offense. But I still think even though it's based on the underlying offense, you're still going to have situations where the public would rightly say, how could this person who's on probation, who went out and committed this violent offense, not be getting at least a half point anymore? Why are we reducing the sentence there? That doesn't seem consistent with public safety. Or if it's not reducing the sentence, why are we not treating it as a more serious situation that requires a different response?
I'll just repeat that we are treating it as a more serious situation in that criminal history does accrue. In that case, the severity level of the new crime will be higher, and all of the sentences at higher severity levels are higher. It will probably have that mandatory minimum come into play. There are multiple ways in which we definitely treat those offenses more seriously. So I just don't think that this is the way to do that, to accomplish that. Commissioner Larkin?
And I just think we have to be honest with the public, because despite all those things which exist now, as it exists now, our fifth-degree possession offender who goes out and commits an ag robbery is supposed to have this half point that means something. And under Bogdanovic, we're saying it doesn't mean anything. We're taking that away. So I guess that's sort of a hard sell in my mind, given that our primary obligation is supposed to be public safety, and given what we're hearing from the public, what we're seeing in the papers about rising crime.
Commissioner Schnell and then Commissioner Middlebrook.
I'm going to ask a really naive question, because I just am not doing this work day to day in terms of the application, and I hear the stuff around just how you apply this, and I would just like to ask, because I don't know, like, how complicated it will be. What would it take? What does it take to sort through that? I mean, what's the practical application of this, and do we end up having problems of inconsistent practice or whatever as a result of this? That's what I'm asking, and I'm asking people who would do this every day.
Sounds like he's asking more Knudsen and Valerie.
Well, we used to do it every day, at least. I think Judge Knudsen might be the one that's actually doing this. I mean, the guidelines are complex. There's just generally speaking, I don't think there's anything in Judge Larkin's or Commissioner Larkin's new proposal that is, that complex. But maybe the probation perspective on this would be helpful from Vice Chair Estrada. I mean, the judges rely on worksheets that are prepared by the probation office, and in my experience, where we've had challenges understanding the guidelines, that's how those challenges manifest themselves, on inaccurate worksheets that are relied upon by judges, and then creating problems that sometimes end up getting appealed. From my standpoint, I remain troubled by the notion that this body in 2019 intended that half point to have some impact. And, because of technical issues that weren't anticipated, it hasn't had that impact. And so, the effort to try to fix that has been the odyssey that we've been on, the last year. And, it strikes me that using an unpublished Court of Appeals case to define commission policy guidelines related to this, I agree with Commissioner Larkin. That does strike me as problematic. We're in essence substituting, the judgment for a three-judge panel of the Court of Appeals for our judgment. And, those of you who were on the commission in 2019 are going to be in a better position than me to address this. But it seems to me that going from a half point to nothing is problematic. In response to your question, Commissioner Schnell, I mean, I don't think there's anything in either of these proposals that is, unreasonably complicated, but, it would require training, it would require some effort. And could there be stumbles along the way? Sure, there absolutely could be.
Commissioner Estrada, did you want to?
Yeah, Your Honor, Chair. It would be incredibly complicated. I think it's more feasible in those smaller counties, but in the larger counties, it is much more difficult. Again, I'm going to go to the departures. I'm going to also ask you guys to think about those interstate cases where probation officers are really having to track down court records, and there's not the best records in systems, whether it's Minnesota or out of state. And then we're trying to balance, like, where does this apply? Is it equivalent to this? And is this considered a departure? Would it be considered a departure in Minnesota, even though it's not considered a departure in another state? There's a lot of complications that go into that. There's a lot of time that goes into that, and there's a lot of room for human error in that. And with that, it's going to create additional disparities. And I think it's going to create additional disparities, not just racially, but geographically as well. So I do think it's a lot more complex, and training, we can train all we want. And the reality is that there's so much turnover going on back and forth, and we only have access to certain information. So I would highlight that in terms of the complications of it.
Madam Chair, if I could just make one comment about Commissioner Estrada's, Vice Chair Estrada's point. I do sympathize with the complexity, and it is that mitigated, determining whether the custody status was the result of a mitigated dispositional departure that gives staff the most concern in terms of being a new task that probation officers have never had to do before. I will say, with respect to the out-of-state offenses, in drafting the language, I did say these guidelines, a mitigated departure from these guidelines, and my intent in saying these guidelines was, we're only talking about Minnesota. Do not ask us to try to figure out whether this is a mitigated departure from the Washington guidelines or whatnot. So.
Commissioner Middlebrook was in waiting, so we'll go with her first.
Thank you, Madam Chair.
Yeah.
I want to just clarify something from you, Commissioner Larkin. When you're talking about, both of these proposals are basically not counting custody status for those low-level offenses, for the severity level 1 and 2, D1 and 2, gross misdemeanors, and the targeted misdemeanors. Both of them on the first prong is that, where it's not counting. So when you're talking about that they're not getting any consequence for being on custody status, in your example, that would be the same for both of them. And so I guess I don't see where when you keep talking about the public safety, all of us here, I think, are concerned about the repeat violent offenders, and that is not what this is even about. So I guess maybe my question to you is also, is it the concern with basically rounding down the half point for those low-level offenses, the low-level property and drug offenses? Is the concern really then about those that are at the end of the grid? The repeat offenders where their criminal history score is 7 or more?
Well, my concern goes beyond that for the reason that this half point was supposed to count for something. And if we go with Bogdanovic, it counts for nothing. So we've kind of given everybody a break, no matter what their circumstances are, no matter what they're on probation for, no matter what their new crime is. And I do think, it gets at the repeat violent offender because again, if it's, I'm on probation for 5th degree possession, no big deal. But now I commit an aggravated robbery. it seems to me that that is a repeat offender with a violent offense that warrants at the very least keeping the half point we were supposed to give that person. Why are we giving that person a break and taking away the half point?
So I just want to clarify, I'm looking at your proposal though. So in the example we had where a person had a prior 5th degree drug possession, and now they've committed an ag robbery, even under your proposal, they would not receive that full point. They wouldn't receive any custody status point.
Because
Custody status is dependent on the prior.
well, I told you my proposal is not great. Bogdanovic is not great. To simply say we're going to eliminate the half point across the board. I think the best proposal that I've come up with, since I seem to be the only one coming up with proposals, is the half point grid. Because the half point grid treats everyone the same. And when we vetted that, we heard, well, we can't have a half point grid. That'll be too complicated because we'll have a horizontal grid instead of a vertical grid, and we won't have case examples. And then yet when the fellow from Washington came in and we were told, look how great this is, what Washington did, they showed us a grid that was 3 pages of horizontal grids with small print with no examples, and it was like much more complicated than the half point grid we came up with. So, I mean, I don't think we should go with Bogdanovic because it completely eliminates the half point for everyone, and that was not the intent of the commission when it came up with a half point.
All right. I'm looking at the language to make sure I'm understanding how this works.
You want me to walk the commission through the language, Madam Chair?
Might be useful if you can. I mean, is it possible for you to put it, like, we can't see it.
Yeah, I think so. I'm not sure what's possible today, Madam Chair. Just to reiterate for those coming in late, we are having, and it looks like it's not resolvable today. I apologize for that, but we're having video issues. So unless members of the commission want to turn on their own laptops, cameras, which they're welcome to do, we're not going to have any video today.
Okay.
But I am going to try to display my screen here. All right, so
Oh, okay.
so this is the draft language. I got actually the Word document open just in case, there's somebody wants to make on the fly changes or whatnot. But so 2B2 is custody status at the time of the offense. But what I've done here is inserted a new 2B2A, which defines custody status. And I find that makes it really easy to explain the policy later on, once you go through the hard work of explaining what is custody status. Then it's pretty straightforward to say, okay, if you're on custody status, you get 1 point or you get 2 points. The rest of the policy goes much smoother. So custody status, these are the same types of custody status that are now in the guidelines: probation, parole, supervised release, et cetera. And then these are the general requirements. A status is custody status only when the status followed entry of guilty plea, guilty verdict, or conviction. That's in the existing guidelines. But then I created a new term here called custody offense, which is also used later on. I think it makes everything read more smoothly. And then these are the different custody offenses. These are currently in the guidelines. But it's consolidated a little bit just because we don't have the half point. So this is kind of how the guidelines laid out the offenses in 2018, basically. Felony EJJ, non-traffic gross misdemeanor DWI, or targeted misdemeanor. And then under 2B2A3, there's an additional requirement for certain felony custody offenses. So for a custody offense currently assigned a severity level ranking 1 or 2 on the standard grid, or D1 or D2 on the drug offender grid. So these are your low-level non-sex offenses, basically. A status is not a custody status unless either or both of the following conditions apply. And I use this terminology because I was told and or is not an acceptable thing to put in legal writing. So either or both of the following conditions. The custody status was the result of a mitigated dispositional departure from these guidelines. The total criminal history score applicable to the current offense, excluding the custody status point, is 6 or more. So if either one of those things is true, then the custody status will apply even to a 1 or 2 or D1 or D2. But if both of those are false, then custody status will not apply. That's the felony side. Then the misdemeanor side just has that one requirement that the criminal history score applicable to the current offense, including custody status point, is 6 or more. And Madam Chair, I don't know if you were making a serious proposal, but if you were intending to, you were suggesting maybe a middle ground between the two proposals. As far as drafting goes, what I would do is just cross out number 3 here, and I would change number 4 to just say additional requirement for certain custody offenses. And then in addition to non-traffic gross misdemeanor DWI, targeted misdemeanor, I would add D1, D2, 1, and 2 felonies. So then the only thing that could get you a criminal history score for those offenses is if the total criminal history score applicable to the current offense is 6 or more. So what that would do, if I understood you correctly, Madam Chair, is mean that the only consequence you could get for a custody status for a low-level offense, including 1 and 2 felonies, would be if you had a criminal history score of 6 or more without the custody status. That's what I understood you to say, and I think you could do that pretty easily here just by slightly modifying subparagraph 4 and deleting subparagraph 3.
Yeah, we have questions already. I didn't see who raised their hand first. Middlebrook, Commissioner Middlebrook, and then Larkin.
Me first? Oh, thanks, Madam Chair. I guess my question to Nate is, are you talking, if you did that, when you're talking about basically kind of a middle ground here, it would be adding the 3 months, is that right?
Yes, yeah, and I don't know if I'm the only one who says 3-month bump. I apologize if I am, but that's just what I've always thought of it as. The additional 3 months sentence duration that's added to the sentence, if you're essentially off the charts and you have a custody status, you get an additional 3 months duration.
Okay, not a full point, just the 3 months.
Well, it would be a
I
full
guess it
point, but
doesn't matter. I guess it doesn't matter.
the only thing that full point would get you is a 3-month duration.
Okay.
So it would be a full point. So essentially the mechanics would be you'd get the point, but that point is taken away then in this paragraph unless your criminal history score is 6 or more without the custody status point. That's how that would work. And then we have the exceptions.
Wait, Commissioner Larkin also had a question. So
I guess I'm just a suggestion. It's hard for me to, it seems like as a group, I just might suggest, it would be good to just vote on something and decide what the rule is going to be and then go to the language, kind of be studying the language and talking about modifying the language when we don't have an agreement regarding what our goal is. I don't know if that's helpful.
yeah, no, I actually wanted to see it because I was understanding your proposal in a different way a moment ago, and I wanted to make sure I understood how
Certainly.
it worked. But I agree that we shouldn't be talking about modifications at this time. Commissioner Middleton.
I was just going to comment on Commissioner Larkin. I guess maybe, I mean, if we're going to make any amendments or any changes, we do need to do that before we vote. Rather,
Right, but what we were just discussing wasn't really an amendment. It was a whole different proposal.
kind of an amendment to yours and one to the Bogdanovich one.
I just think big picture, I mean, again, I'm not saying my proposal is the best proposal, but like, I'm alone here trying to come up with proposals. And I just really encourage us not to simply say, well, we're gonna adopt Bogdanovich with a 3-month bump, because we are significantly reducing what the commission did last time when it went from 1 point to a half point by eliminating the half point altogether. And at the end of the day, as you saw last year, the public needs to buy into this. And to say, well, it doesn't matter that you're on probation, you've committed more crimes, unless you already have 6 prior points. I mean, I would think the public would say, that's crazy. If you have 6 prior points, why do you get to have that many offenses before somebody says, okay, stop committing crimes while you're on probation? That's bad. There just is sort of a bad appearance to that approach.
Okay, can we just,
Sure, and then subparagraph 5 is exceptions. This is all current guidelines, except I think it's a little easier to understand as it's organized here, except for small Roman numeral 1. I talked about that on the first page. That's probation or other custody status that occurs while adjudication of guilt is stayed. And I have footnote 2 on the first page that explains why we have that here. It was the commission's intent. Prior to 2018, the guidelines said that custody status counted if you had a 152.18 stay of adjudication. Minnesota Statute 152.18 is a special statutory stay of adjudication that applies only in certain circumstances to certain low-level drug offenses. So it's a statutory relief that the legislature provided for certain low-level drug offenses. But it's possible for the court to give a stay of adjudication in other cases on the court's own initiative or at the court's discretion. So what the commission's concern was back in 2018 is, wait a minute, why are we counting custody status for 152.18 stays of adjudication, but we're not counting it for other stays of adjudication? That doesn't make sense. That's irrational. So they just deleted the 152.18 stay of adjudication. It was their intent at the time, and it's my citation to that is a link in the footnote, footnote 2. But they spell out their intent in the report to the legislature. It was their intent that stays of adjudication shouldn't count. But by just taking out 152.18s, it didn't necessarily make that crystal clear. So we've had some questions on that. So I wanted to make it crystal clear by adding this small Roman numeral 1. But the others are existing policy. So then we get to B, which is the assignment of the custody status point. And it's now very simple. Assign 1 custody status point if the current offense was committed while in a custody status. And then B2 is just defining what it means to have been committed in a custody status if, say, it's an offense that's committed over a period of months. Some offenses are like that. Basically, if you were in a custody status at any point during that time. And then C is 2 custody status points. Assign 2 custody status points rather than 1. I added that. I think that's implied, but it doesn't say that. Assign 2 custody status points rather than 1 if the current offense was committed in custody status, and both the current offense and the custody offense are sex offenses. And failure to register as a predatory offender is not considered a sex offense for these purposes. Then we have the 3-month bump, which this is the same. I did talk with Commissioner Larkin, and she pointed out, and this is existing guidelines language, but I think she's got a point here. This i.e. 7 or more in the current guidelines, there's arguably some ambiguity there. Does the 7 or more refer to the maximum score on the applicable grid, or does it refer to the total criminal history score? Obviously, it's referring to the total criminal history score. The maximum score on the applicable grid is not 7 or more. I think adding the word is in front of 7 would solve that ambiguity. And I noticed when I was doing the write-up, I had in the first page, I had is. So I would suggest adding the word is before the number 7 in i.e. 7 or more. Just for ambiguity, if nobody objects to that. And then everything else is pretty much the same. Then we have waiver. I made some just style issues to waiver, and but it's all pretty much the same.
all right. Any further discussion?
I want, Commissioner Middlebrook? Thank you, Madam Chair. I've got one other question. Maybe this could go to Vice Chair Estrada. On the worksheet, if this proposal is where they get a custody status point, 1 point, if their criminal history score is 7 or more. On the worksheet, is it going to show up as 1 point? So then it's going to be confusing for totaling them up, and it will look like it applies to everything.
The way the worksheet works right now is it still has the half point in it, so it automatically rounds down for us. So it's going to show up as 6, and people are going to have to manually add the points unless we can get the DLC to help us out with changing the electronic form.
Yeah, we would initiate it. We would ask that, we would work with the DOC's excellent IT staff to change the electronic worksheet system. So it would say 0. So it's problematic because it can't be automatically calculated because we don't have a data field for whether the custody was mitigated dispositional departure. But we could automatically calculate if the criminal history score was high enough for the current offense, if it was 6 or more without the custody status point, then it would just put 1 in the custody status box and then total up to 7 or 8 or whatever it is. And then the duration would increase by 3 months on the electronic worksheet system. So it's pretty straightforward, other than the fact that we're going to have some kind of manual override for the mitigated dispositional departure, because I don't see how, at least from what I know, I don't see how that can be automated.
I'm realizing that Commissioner Ladd is not on as a panelist anymore. I think she's down. She must have had to disconnect and reconnect. So maybe
She's
someone-
communicating.
I'm still here.
with me.
You are?
I'm still
Okay.
here.
Okay. You didn't look like, well, I wanted to ask if you have any comments to make because I know how hard it is to butt in when you're on a phone. So is there anything that you want to say before we move to a vote?
Well, I'm not going to repeat what's already been said, but I do concur with the thoughts that Commissioner Moore has stated, Commissioner Larkin. I think we need to take a vote and see where this goes and just move forward, because it doesn't sound like it's probably going to go forward with the current proposal that's on the floor, but I think we just need to take a vote and move forward.
All right. Commissioner Hansi, did you want to make any comments before we move forward? Commissioner Hansi, did you want to say anything? We'll assume no. Commissioner Moore?
Yes, thank you, Madam Chair. I was wondering if Commissioner Schnell would have any thoughts on this 160 prison bed impact. I don't, being newer on the commission, I guess I don't have a good sense of, what effect fiscally and staff-wise and otherwise, that capacity-wise that would have on the state prison system. And, I don't, unfair to push on a spot like that, but if you get any general thoughts on that, I'd be interested.
Commissioner Schnell?
I would just, it's one of the things I was going to hope to ask to have at least some discussion on going forward, because, with our folks and with the Guidelines Commission have been doing some stuff around projections, as we know. And prior to COVID, we were at capacity, right around 9,500 beds. That dropped dramatically. We were down to about 7,200. Now we're about 8,000. We project that we will probably within about a year and a half or so, right, roughly, be at capacity. And part of that's just backlog. This is not, substantive statutory changes. So that's kind of where we sit. And I think this will be one of the conversations that ultimately, the legislature is going to have to look at, is there going to be the need to ultimately build something or to expand something? I don't know. That's going to be the factor. If that 9,500 is where we're at, then unless there are alternative options looked at. But that's kind of where things are right now today.
Thank you.
All right, last call. Any other comments? All right, let's go ahead and take a vote.
All right. To the Larkin motion to advance to a public hearing the restoration of the fall custody status point with special requirements for low-level custody offenses as outlined in staff papers 6B1. As modified with the is.
Accept that as a friendly amendment.
As modified in the meeting. Estrada?
Yes, no, sorry, no.
Estrada, no. Hansi?
No.
Hansi, no. Ibrahim, absent. Knutson?
Yes.
I told Nick that I will be dropping off the loaner. And I can put the keys in the side.
Tanya?
All right. I meant to mute Tanya and I muted the whole room. I muted everybody, so I think I just unmuted the room. So I think we'll find out in a minute. No, we don't have anybody else on the line. Okay. So continuing on with roll call on the Larkin motion. Ladd?
You muted her.
She did it.
Oh, I probably did mute Ladd. All right. Let's see if I can remember which phone number it was. All right. On the Larkin motion, Ladd?
Yes.
She just,
Ladd, yes. Larkin?
yes.
Larkin, yes. Middlebrook?
No.
Middlebrook, no. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
No.
Chair Mitchell, no. Madam Chair, there are 6 votes in favor, no votes, 4 votes opposed.
All right, with that, the motion is approved. All right, so that finishes out the custody status issue. So now item 7 is recommendations to the legislature resulting from the sex trafficking review.
All right. Thank you, Madam Chair. So I have 2 documents in your packet. One is you're welcome to read. The other is a lot shorter. So let's take a look at the one that's a lot shorter.
Got to tell us what that is.
It's 7A.
Okay.
It's a 1 slideshow here. Let's see. All right, so the background in there is you do have the authority, in fact, the statutory responsibility to make recommendations to the legislature from time to time with respect to criminal law, criminal procedures, and other aspects of sentencing. These are 3 issues that came up during the sex trafficking review. They don't all necessarily pertain to sex trafficking, but they're essentially, we came across them as we were doing the work for you in the sex trafficking review. The first is that aggravated sex trafficking doesn't define important technical terms. And those technical terms are the terms it has to do with they're essentially the labor trafficking terms, debt bondage and forced labor or services. So it's clear that the legislature borrowed those terms from the labor trafficking statute. But but the labor trafficking definitions are limited in scope to only include the labor trafficking statute. We're simply recommending that the labor trafficking definitions also include the sex trafficking statute, so that the definitions are cross-referenced. The second recommendation we're recommending is that the legislature update one of the age thresholds to under or at least 14. So in 2021, the legislature basically made a wholesale change to the age threshold in crim sex cases, in child pornography cases, and sex trafficking cases, where it used to be the cutoff was whether the child was under the age of 13 or 13 or older. It changed it to whether the child was under the age of 14 or 14 or older. But in doing that, it missed one. So there's literally an inconsistency now where, plus, I don't know if you call it an inconsistency, but if a child is exactly 13 years old, under the current statute, that could be either charged as a more serious offense or a less serious offense. Clearly, it was a mistake. The legislature made the change in one, but it didn't make the change in the other. And we would just ask that the commission recommend that the legislature change that sixth reference so that all the age thresholds are consistent. The final recommendation that we're recommending, that you recommend to the legislature, is that the statutory violent crime list, and we talked about the statutory violent crime list in the paper on the severe violent offense list. That was, we assumed, kind of the starting point for the severe violent offense list. And we noticed in there that first degree witness tampering is on the list, but aggravated first degree witness tampering is not on the list. Aggravated first degree witness tampering is more violent than first degree witness tampering. So it really doesn't make any sense for first degree witness tampering to be on the list and aggravated first degree witness tampering not to be on the list. So we're recommending really an alternative here. Either add aggravated first degree witness tampering to the list, or just replace aggravated first degree with aggravated first degree. As it's written, the commission doesn't take a position on which of those two things the legislature should do, but either one would make it rational, and it's not really rational right now. And there's plenty of reading you can do on all of those recommendations if you like, but that's kind of the nutshell version. If the commission has any questions, I'd be happy to answer them. Oh, and this is not for action today. This is for inclusion in the report to the legislature. So the action will be when you approve the report to the legislature in January. We'll be working on the report to the legislature at the next meeting, we hope. But if you have any suggestions for me now as we begin the drafting of the report to the legislature, it would be really helpful to have those suggestions or guidance at this point. Again, not for action, but anything that seems like we're way off base or we're missing something, or for that matter, if there's something else you want to recommend, that's all fair game. But we'll be moving on to action in later meetings.
Well, I was going to actually go further and say, if anyone wants to take action today, we could, and then staff would have their direction for putting it in the final report. This is not a change to the guidelines, so it doesn't require the 2-meeting rule, but it doesn't matter to me if you want to wait till next time. The first two, really, to me, I think we need to decide one way or the other if we want to make those recommendations to the legislature, because it would be part of our review of aggravated sex trafficking. We found those things, or staff found those things as we were doing that review. So I think it makes sense, since they came to our attention, to go ahead and let the legislature, give the legislature a heads up about those things. They seem to me to be very minor. So, I think we probably should include that, but I'd be curious if anyone else has any thoughts on that. Commissioner Larkin.
I have no objection. I think they're useful changes to recommend.
I'll move it.
Commissioner Schnell moves to add those first two recommendations. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion on the motion? Hearing none, we'll let Nate take note of the motion and then he'll take the roll.
To the Schnell motion to include the first two staff recommendations in the 2023 report to the legislature. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. I don't have any particular thoughts on the last one, so I'd leave it to the commission if you all have thoughts on that one.
Madam Chair.
Commissioner Schnell?
I guess, my opinion, I think that when you look at just the what first degree is versus the aggravated, I think to the executive director's point, it simply makes sense that the more severe of the two be included, and how that's worded, I don't have a strong opinion, but I think to make sure that the severity is reflected in a recommendation, which I think is reflected in the staff recommendation. And I would move that if nobody has any objection to that.
We have a motion. Does anyone want to second that?
Second.
Commissioner Moore seconds. Marath was almost there. Any other discussion? All right, hearing none. Go ahead and take the vote when you're ready.
To the Schnell motion to include the third staff recommendation in the 2023 report to the legislature. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, it's approved unanimously. All right, we got part of our report written. We'll see what happens next. Okay, moving on. I lost my place on the agenda. Executive Director's report.
All right, thank you, Madam Chair. So I've got 4 items on the report here. The first is the annual report to the legislature timelines. We do have, we are kind of coming up against the timeline here. So we have, when I got this job, I looked at the statute and I said, I have one job that I have to do, and that is I've got to get the report to the legislature done by January 15th. So there will be a report submitted by January 13th, since the 15th is Sunday. And your meeting is right before that. I think it's the Thursday right before that. So we really would like to have the report in a semi-final state by the end of the meeting in December. It's not that we can't make edits in January, but the main action item in January should be taking final action on the proposals to change the guidelines and any final tweaks to the report to the legislature. Obviously, you won't have seen the final draft in December. You'll have a draft in December. We'll work on December is really the working meeting, and then we'll finalize that in January. There will be language in the draft report that we'll give you in December that will assume that everything that was advanced to public hearing is passed by the commission. I don't mean by that to imply that that's actually what the commission is going to do, but we're we're just going to take that as our operating assumption that everything will be finalized. And obviously, if it's not, we'll change the report to the legislature accordingly. But the final action on those changes that you took today will occur in January, after the public hearing. So in December, we're going to have a public hearing, and the public, and I guess this kind of jumps to item 8D, which is where is the December meeting going to be? Based on the fact that we're going to have a public hearing, we're going to have the meeting, if it's okay with you, in the Capitol, room G3. It's well suited for a public hearing. They've got good audio visual, and we've used it before. So I think that's a good room for that. So if I could, Madam Chair, do we have time? Can I just put up some slides on our data?
Yeah.
So we will be giving you a full data presentation at the next meeting. And the reason we'll be doing that is because that's part of your report to the legislature. We customarily give to the legislature a summary of what's happening in the world of sentencing. And we just finalized the 2021 data set. Bear with me, please.
There you go. Oh, it's showing it in presentation mode for some reason.
Okay, so this just shows you the 2021 case volume, and this kind of goes to Commissioner Schnell's point earlier about prison population. You can think of this, I don't know what the final economic chart looks like as far as how the economy did with COVID, but it was predicted to be kind of a V-shaped curve. And I think it kind of was a V-shaped curve. It went down really fast, but then it bounced up really fast. We're kind of seeing that here. You can kind of see the V-shape in terms of case volume. And I think to Commissioner Schnell's point, we're kind of seeing a little bit of a V-shape in terms of the curve with respect to the prison population itself. So certainly 14,429 felony cases sentenced in 2021 is not an exceptionally high number. You can see it hasn't been that low for a decade, but it's certainly quite a bit higher than we saw in 2020. And obviously these are both exceptional years. I believe the Chief Justice has indicated that the volume isn't, well, that the backlog isn't supposed to be eliminated until next summer, I think is the target.
Yeah, the target is July of 2023. There's been good progress made by the district courts in that the numbers have come down dramatically.
Particularly in the first judicial district.
So, and I mean, from a data point of view, it does bring us up, like, when can we assume that we have a normal year? I'm not sure that 2020, 2021, or 2022, or 2023 are going to be normal years. So we're kind of going to be using 2019 as our baseline, I think, for a long time. But this shows you the annual percent change in the number of cases sentenced. And you can see that this year was the highest percent change in the number of cases sentenced in the guidelines era. So it's a significant increase, but that's only because, well, I don't know if it's oversimplifying it to say it's only because, but it's obviously connected with the fact that 2020 was the highest decrease in the guidelines era at 34%. So that's just a taste of what we're going to be looking at next time. We'll have your full data presentation. We couldn't have that ready today, but you know, a lot of information about departures and race information and things that the legislature and the commission, I think, find very interesting. My second item on my report has to do with budget change items. We obviously talked about those last time, but we didn't have the numbers on everything, particularly the minute numbers were not in, and those are all in the material. The final thing I wanted to talk about is the term of the governor-appointed commission members. So unless you are a judge or you are the commissioner of corrections, you have been appointed by the governor to your seat and judge or justice. So your terms are coterminous with the governor, which means regardless of whether Governor Walz is reelected, your terms will end in January. The governor, if Governor Walz is reelected, his timeline is to look at I think it's March or April, I can't remember which, but that's his timeline for when he's going to be looking at filling the vacancies on the Sentencing Guidelines Commission. So 2 points. One is you continue to serve until your successor is appointed. And 2 is if you want to continue serving on the commission, you have to reapply. The application is on the Secretary of State's portal. So you should go to the Secretary of State's and it's open now. So it opened a few weeks ago. So, and some people have already started applying. So, and you can see who's applied. So if you want to continue serving on the commission, you should go to that portal and apply. And I should have said this earlier, but we did have a public comment that somebody was unable to raise their hand and be called on, which is concerning to me from a technology point of view. We did test their hand raising before the meeting, and it seems to work okay. And I will ask staff at this point to raise their hand. But if you are a member of the public and you are not able to raise your hand, I would ask you to call 651-296-0144 right now for technical assistance, or they'll just let me know that you're not able to raise your hand. If you are a member of the.
Can you just do the unmute? Can we,
Unmute everybody?
yeah, can we just do that again?
We could unmute everybody. It just seemed kind of intrusive. I mean, we heard some bordering on private conversations before we've done that. So I'm a little reluctant to unmute everybody. I think the hand raising works.
How do they raise their hands? Do you know? Can you
I-
give instructions?
I don't know. Shauna, would you mind telling us how somebody would raise their hands? Shauna's on as an attendee, so she should know. She just raised her hand.
Yeah, there's a button on the lower right-hand side of the screen.
So on her computer, there's a button on the lower right side of the screen that allows you to raise your hand. Right now, I don't see anybody who's raised their hand.
I see Shauna's. I think the issue, okay, so we have one call-in user.
Yeah, and I'll have
So
to.
that's going to be different. Yeah, okay.
The three staff raised their hand.
Commissioner Larkin, did you want to say something?
Just if we're getting to the point of public comment, I just want to raise the issue of, at what point do we get to talk about changing comment 2B 205, which says there needs to be a conviction? Should that be part of what goes to the public hearing as well? And taking us back to custody, or is that something we could talk about in January? It seems like that's something we should clean up sooner than later. Do we need to? But I don't even know that we can vote on that today since we've not discussed that before.
Yeah, procedurally, it's not the same as changing the guidelines.
It's not.
So maybe, because I would like to be able to take a look at the language.
Absolutely.
Yeah.
But I think it would be helpful. It isn't, if we're going to do it, we could probably get it done before January.
Madam Chair, may I make a
Yes.
suggestion? So in the past, I've actually made a public comment. Because, there was something with the draft language that I wrote that I was like, oh, this should be changed. So I made a public comment suggesting a change to the language. So I think it's possible for a commission member to make a public comment in writing suggesting language changes to the commentary. And because the commentary is not guidelines, I'm sure that would have no problem just kind of being part of the public record. And then you can make the change to the commentary in January when you're taking final action on the proposal.
Thank you. That's a good suggestion.
Okay. Talk us through the procedure that you want people to follow in order to try to to do public comment.
All right, so Jill, can you confirm that Nobody's called in.
No one is called.
No one, okay, so I'm confirming that nobody's called in. First of all, we do have some members from the public, and I'm chuckling because outside of a public hearing, I don't think we've had any members of the public in attendance at our meetings since we've gone to hybrid meetings. So this is a new thing, but we do have a couple of members from the public. So Madam Chair, perhaps you can call on them first to see if anybody present in the room wants to make a comment.
Oh, that's right. Oh, I'm so sorry. We do have, we have one member of the public in the room. Do you want to make any comments today?
Yes, I do.
Two? I'm so sorry. We have two. I forgot. I didn't look both directions. Would either of you like to make public comments today?
I do.
Okay, why don't you come up to the front here so that we can all hear you. Introduce yourself for the record, and then please go ahead with your comment.
Madam Chair and Commissioners, my name is David Zimmer. I'm a retired Hennepin County Sheriff's Captain. I served in law enforcement for 33 years. I currently serve as a policy fellow with Center of the American Experiment, focusing on public safety issues. I offer these comments in that capacity. The statutory direction of this commission is clear. In establishing and modifying the sentencing guidelines, the primary consideration of the commission shall be public safety. Arguably, the work of the current commission has too often failed to maintain public safety as its primary consideration. I don't say that with malice or to suggest that this commission has intentionally set out to harm public safety, but good intentions alone don't equate to good public safety policy. This commission has failed to make clear in its work that it values the impact of crime on law-abiding citizens more than it values the impact of sentences on offenders. In the mid-1990s, Minnesota experienced a significant rise in crime, leading to our designation by the New York Times as Murderapolis. Back then, the criminal justice system responded resolutely with the backing of our political leadership to quash the violence. I was personally part of that, working in drug and violent crime task forces and with the Minneapolis Police Homicide Unit. This proactive, tough-on-crime approach response had a positive effect. For nearly 22 consecutive years, Minnesota experienced a reduction in serious crimes known as Part 1 crimes, dropping nearly 50% over those 22 years. Then in 2018, well before COVID, well before George Floyd, and more importantly, well before the national rise in crime that began in 2020, Minnesota began seeing a rise in crime that has overtaken our state. For the first time in history, in 2020, we surpassed the national average in Part 1 crimes. Since 2018, Minnesota has seen a 36% increase in our violent crime rate. During that same period, our state prison system reports a 21.5% decrease in incarceration. Also during that time, our judges have set 3 consecutive records for downward dispositional departures from presumptive prison commitments. According to the Vera Institute, Minnesota now has the 48th lowest prison incarceration rate in the nation, sitting at 132 per 100,000. The national average is 303. The reduction in our incarceration rate contrasts poorly against our increased crime rate and should resonate with this commission as it debates policy that further reduces our incarceration rate. Former U.S. Attorney Attorney General Bill Barr recently wrote a commentary for the Wall Street Journal entitled "Rising Crime Rates Are a Policy Choice." In it, Barr described clearly how reform-minded policies in the 1960s turned state justice systems into revolving doors. The violent crime rate went from 160 in 1960 to 758 per 100,000 in 1991. In response, the Bush and the Clinton administrations targeted violent crime through tough on crime policies that valued incapacitating criminals through incarceration. By 2014, the crime rate had been cut by 50%, precisely because that offender cohort had been incapacitated. When crime spikes, as it has in Minnesota since 2018, law-abiding citizens deserve protection promptly, not over decades as we debate root causes and disparities. Barr ended his piece with this: the very purpose of government is to secure a peaceful society. Making life safe for law-abiding citizens by protecting them from violent predators. Progressive politicians are doing the opposite, lighting the lives of the law-abiding with their warped solicitude for the criminal few. It's time for a return to sanity. I urge this commission to keep those sentiments in mind as you debate and propose modifications to the sentencing guidelines going forward. Thank you.
Thank you. All right.
Madam Chair, if I could just ask, could the staff members who are now in the room please raise your hand just to confirm that you can hear me? Okay. So, Madam Chair, does anybody else in the room?
Anyone else? Okay.
All right.
No one else in the room would like to speak?
And nobody is raising their hand, so I'm just going to unmute. There's a call-in user with a 218 area code. I'm going to unmute that person now. I've unmuted your telephone line. Do you wish to make a comment?
Hi, thank you. Yes, this is Michelle Hipsag. I'm your guys' Karen from the North. I've been at all of these meetings, as many of them that I can attend. And first off, thank you for the gentleman who just spoke. Impeccable words, and thank you for your service. Really do appreciate that, and thank you for what you said. Thank you, Judge Larkin, for speaking for and being an advocate for the victims of crime. You have no idea how much that is appreciated. And thank you to you other five that also have some common sense. It's restored some of my faith in humanity. This issue has been a hot issue. It's a hot issue right now. I don't even know why we're wasting time, again, taxpayer money, debating this. There's so much concern for the criminal and numbers and dollars, but there is no concern, I don't see, for the victims. And, you know, what are we paying out in crime services for victims? I mean, do we have those numbers? Like, what is the cost of that? Everybody's worried about a cost of a federal prison bed. What's the cost on these victims? And you can't even put a price on their sanity and the emotional and mental trauma that victims endure after crime. So as far as the December meeting, I really do look forward to it because I will be there, whether it's online or in person. And we'll just, I guess, the public is going to have to rally the troops because this is just unconstitutional. This is a crime against the public. Thank you.
Thank you. Any other comments before we close the meeting?
I'd like to speak.
Commissioner
on
Estrada?
some of the public hearing. I recognize that every victim has a different experience. My condolences are with victims who are no longer with us and for their families. For the last 6, maybe 7 years, I have sat on this commission in the role of a probation officer, and I have never stepped in the role as the victim or shared my story. But time and time again, I hear from either members of the public or even members of this commission that we are not taking victims into account. And I will speak for myself here and say that I have been beaten to the point that my face has been unrecognizable, and I have had my spine broken in 6 places. I've had a gun pointed to my head on 3 different occasions. There is not a single vote, there is not a single discussion where victims are not in my mind or in my consideration. But in this role as a probation officer and in my role for the last 17 years working in this field, I have had the honor to work with people, victims, families, and clients alike, and see people succeed. And that is the majority. I have seen the light bulbs go off in COG skills. I don't just see people when they're in court for a violation or for sentencing. I don't see people for an appearance. People that we are working with, and this isn't to say everyone, because there are some people, and as a PO, there are times where I have to say, Your Honor, I am recommending that this person go to prison because of safety concerns. But I've sat here time and time again with this idea, and again, it's been members of this commission who have made these accusations, and they're quite honestly wrong. And when I make my choices to vote in a certain way, I make them with the idea of having the best interest of others, everybody, and in light of others. And I am concerned with policies that we have passed. I'm concerned with the policy that we just passed, because we are throwing the baby out with the bathwater. We are making policy based on fear-based policy. We are punishing all of these other people who are in a situation that are not in the examples of the worst case examples that we've heard. So again, my condolences to victims, my condolences to people, and I get it. When these things happen to me, my family were the first ones to say, I want these people to pay who did this to you. And it was very hard for me to be able to say, no, that's not what I want. I want this person to get help. And as a probation officer, the victims that call me every day, as a supervisor, the victims that call me every day are often the one who will say, I don't want this person to go to jail. I want them to get help. And there's a large pool of victims that are not here testifying because they don't have the ability to either miss work or log on because resources, I mean, this is internets and being able to come for transportation. So there's a big pool that's also missing. So I appreciate the feedback, but I just ask that, as we continue to look at compassion, that we're giving that compassion all the way around.
Thank you. Ma'am, would you like to comment now? Please come forward and state your name, and then please go ahead and make your comment.
Thank you. Commissioner, Vice Chair Estrada, thank you. You compelled me to speak. My name is LaTanya Reeves, and I'm a Hennepin County Probation Officer. I supervise high-risk clients and elderly predatory offenders. And I appreciate the comment that you made about looking at this from the lens of clients. My son was been shot. Both of my children have been shot. I have dealt with a lot of violence in my community. My son currently is sitting in prison for 16 years, sentenced in September of this year for defending himself. I have lost one of my children to the system, and I still do this work every day. I look at the clients as a person who committed an offense on the worst day of their life. And they should not be judged by the worst day of their life, because everyone makes mistakes. Unfortunately, some get caught and some don't. That's the reality that we live in. But they deserve the opportunity to succeed. I've been a probation officer with Hennepin County for many years, and I work every day to make sure that my clients get resources that they need to be able to succeed. And I look at the victims every day of those same offenses. I supervise predatory offenders. I look at people all the time and say, I got to balance both sides. They deserve just as much as anyone else. And in this field, working in probation, we have to have that lens. Cognitive skill, all the tools that we use to make sure that our clients succeed, so they don't come back. That's the goal. Everyone deserves a second chance, everyone. So we need to be looking at the policy that you guys are setting here. I came because I wanted to see this in person. I've been sitting and watching online, and I wanted to see how this goes, and I saw the agenda. So I rearranged my schedule to make sure that I was here to listen. But I'm glad that I get to hear what you said and got to speak and say this. probationers, parolees, whomever they be, community supervision deserve the opportunity to succeed and get all the tools that they need. Based on the policy that you guys say here, you can help that in your way. And so I appreciate listening to you all. I appreciate listening to the comments. The young lady who just spoke, understand how victims are. I understand it. But that can't be the only perspective. And in this space, we gotta look at both sides. And I think you guys are doing a good job of that, so thank you.
Thank you very much. All right, I just want to confirm, is there anyone online who did not previously raise their hand that would like to raise their hand and make a comment? We've got one more chance here. I've not seen anything. All right. So next meeting is December 14th at the Capitol. Public hearing first, meeting right after. All right. With that, the meeting today is adjourned. Thank you, everyone, for your comments today. We'll see you next time.
You said